Okay, we go on the record now. This is case CR 22-21-1624, State versus Lori Vallow. This is the time set on a motion hearing. Actually, we were scheduled to start at 10 o'clock. We've been conducting some scheduling business prior to starting this motion. Let me first make sure that the court reporter is there and able to hear. Madam Court Reporter, are you there?
Yes, Judge, I am. Thank you.
All right, thank you. And I'll ask the clerk in Fremont County if this is being now recorded on the FTR system. Was that a yes from the clerk? Okay, I'm going to wait until we get a response there. I'm not able to hear from the clerk of the court. If you could just acknowledge that you're there and the FTR is functioning, please. Okay, we didn't get an audible, but I did just get a message pop up from the clerk. FTR is functioning. So making sure the record's all being picked up here. This matter is also being live streamed on the court's YouTube channel for public access to this hearing as it's being held remotely. Representing the defendant today, Mr. Archibald and Mr. Thomas. The defendant is here present also, appearing from the Madison County Jail. The state will be represented for purposes of argument at this hearing today by Ms. Rawlings, who I believe is arguing the motion. Is that correct, Ms. Rawlings?
That is correct, Your Honor.
All right, and I believe Mr. Archibald, you'll be arguing in response. Is that correct?
Yes, Your Honor.
Okay. In this case, then, there's been a motion that was filed on May 2nd, and it's titled "A Motion to Find Good Cause to Continue Trial and Prevent Improper Severance." It relates to the issue of the trial settings of this case and the co-defendant Chad Guy Daybell, which is case CR 22-21-1623. In the Daybell case, that matter is set to start jury trial on January 9th, 2023. This case was scheduled to commence trial on October 11th, 2022, after an arraignment that took place on April 19th, wherein the defendant declined to waive her right to speedy trial under Idaho's speedy trial statute, which requires a setting within 6 months of a trial. So the state's now filed its motion seeking a continuance of the trial date to coincide with the other case in January. And if you want to start and present your argument at this time, Ms. Rawlings, you may.
Thank you, Your Honor. The state will largely rely on the motion that has been filed with this court, but we do have a brief argument to make. The court can find good cause to continue Lori Vallow Daybell's trial. As the defense team recognizes in their response, there is a voluminous amount, or I think a mountain of evidence to review in this case. Mitigation experts require significant time to review evidence and prepare argument. And a period of time beyond the 6-month statutory limit lessens the burden on defense counsel to be ready and decreases potential issues on appeal. We feel this alone rises to a legal excuse under State versus Clark, justifying a brief continuance, particularly in a case of this complexity with conspiracy charges and a joint co-defendant. The court has found these cases are properly joined and denied Chad Daybell's request to sever. If there is not a continuance of this current October trial setting, as the court noted, Mr. Daybell's trial is still set in January, and so an improper severance could occur. The interests of judicial economy, procedural efficiency, and ensuring consistent verdicts justify a brief delay to the January trial date. The co-defendant Chad Daybell has waived speedy trial and indicated that his defense would be ready to proceed on the January trial date, but would object to an earlier trial date in October, although Mr. Daybell has not filed any pleadings to that effect. It's just been representations made to the court. The alternatives before the court are to find good cause to continue Lori Vallow Daybell's trial for a brief period, or force the state and co-defendant Chad Daybell to proceed to trial when both have already planned for a January date. We feel it is more equitable to grant the state's request for a brief continuance of Ms. Vallow Daybell's court date, given the complex nature of the case, and to maintain the original January trial date rather than force the state and Chad Daybell to prepare earlier than anticipated. The setting of the trial date in January, given the court's change of venue to a busy district and two of the three parties' needs, we feel is good cause and is an alternative available to the court that allows it to avoid an improper severance. Thank you, Your Honor.
All right, I do have one brief question for you, Ms. Rawlings. There's a couple of different protections under speedy right. One is under Idaho statute 193501, and there is also, I think, separate and individual constitutional protections in speedy trial rights. In your argument, do you indicate that the balancing that the court would use as cited in those cases applies to the statute or the constitutional protection, or both?
I think it probably applies to both based on the Supreme Court's adoption of the Barker v. Wingo standard under State v. Clark. However, I think that for constitutional purposes, there is a time frame that's different. I think that was noted in my motion in terms of what constitutes a constitutional delay or a brief delay in speedy trial. And so I know the court is probably aware that there is case law in Idaho differentiating a defendant's statutory right versus a constitutional violation. That's been heard recently under State v. Clark and some other cases that have basically held that there's a different standard for determining whether a constitutional violation has occurred. And so that's why it was included in the state's motion, is just noting that although Idaho does have this statutory time period, there is a difference that the court can look at in terms of when constitutional violations occur.
Okay, thank you. I appreciate that response. Mr. Archibald, your response.
Your Honor, I'll rely upon the response that I filed. I'd just note that we talked to Mrs. Daybell frequently, and as recently as yesterday, she acknowledges that she still has her right to a speedy trial, and she is not going to waive that right. And so we'll be respectful of the court's decision. Whether it's an October trial setting or not, Mrs. Daybell still wants to exercise that right. She understands we're working hard to get caught up. We're spending a lot of time, and her defense team is spending a lot of time getting caught up, since the state's been involved in this case for over 2 years, and she's been in jail for over 2 years, but her defense team is not. And so, but we're doing all we can.
Okay, I appreciate your response. On that point, Mr. Archibald, you've been appointed for some time, and Mr. Thomas, his appointment's been pretty recent, correct? He was just appointed.
Yes.
Arraignment.
Yes, according to that new criminal rule 44.3, the defendant's not entitled to her full defense team, including co-counsel, until the time of her arraignment. And she wasn't arraigned until a month ago. So that's when the defense team was fully funded.
Okay, I appreciate that. Ms. Rawlings, any rebuttal argument at this time?
I don't believe so, Your Honor. I think the defense response was appropriate given everything, given the defendant's expressed wishes. But as noted in the state's motion, this is kind of a unique position to be in this early in the case, to be asking for this. But we feel that where there are a number of outstanding issues that still need to be determined, including DNA testing of certain evidence that was put off until the cases were brought together again. And because these were properly joined and the court has noted that this is to be one case for trial, we think that it is just more equitable to continue it to the January date.
All right. I'll consider the argument under advisement at this time then and fully submitted. I will review the state's brief again in the response. Because this issue involves important constitutional and statutory rights, I don't want to attempt to make an oral ruling on the motion today because I want to make sure I apply the proper standard of review and properly balance all of the factors I'm required to under the existing case law to make sure I reach the best decision I can on this. So I will be issuing a written decision, and I believe it won't be a big delay until that comes out. So I will take it under advisement and will advise the parties of the court's ruling on this motion through a written memorandum decision and order. So,
Your Honor,
yes.
just briefly, Mr. Pryor is in this hearing. I know that we've had discussions at attorney meetings regarding his position. I don't know if the court wants to make a record of that for purposes of this issue as well.
All right, the motion really does pertain exclusively to the trial setting of the 1624 case that's being heard today, but Mr. Pryor, where these matters have been joined for trial, I do believe it has some effect on you as well. So is there any position you have on the issue at this point?
Judge, my preference is that the court maintains the trial for Mr. Daybell in January as said.
Okay. Thank you for your comment on that issue as well. And then with that in mind, that will conclude the hearing on that motion. So at this time then, we're going to take a brief recess. There's a second motion we're going to call up this morning. That is a matter that was filed under seal and will be a closed hearing. So that will conclude the broadcast of these proceedings on the court's live stream channel. So let's take about a 5-minute break and then we'll call our second motion.